is in keeping with that, and that's why I oppose it, and I ask my colleagues to do the same, and with that I yield back.
Thank you, Mr. Chairman. Good to be with you from the break. I want to follow up on my colleague from Colorado who was following up on my question. You were in here for about 10 minutes, and I tried to subpoena Pam Bondi because she hasn't appeared in front of this committee. She's the only one in the cabinet who has not appeared in the House yet. And so I was told that's out of order. Before the break, you said that she'd be coming in January at a previous hearing, and now she's coming in February, which is fine. So I printed out the calendar of February, and I just figured, like, while we're here, we could just get it on our calendar. So
February 11th.
she's coming the 11th.
That's my understanding.
Perfect. Excellent. The 11th. Perfect. So, by the way, since you're on a roll, should I print out the other months so we can know when Noam is coming as well? Because the Homeland Security Secretary has always come at least once in front of Judiciary a term. So she's not going to come in February. I'll print March, April, May, June, July, August, September, October.
And all you want. We'll work on getting the appropriate cabinet officials in front of the committee. We've had the director of the FBI. We will have the Attorney General in, 4 weeks. We will do our oversight like we're supposed to do our oversight.
All right, thank you, Mr. Chairman. Appreciate it. I didn't expect to get that answer. I was going to go a lot longer, but you saw the calendar and you just spit out the 11th.
When Mr. Neguse asked earlier, I knew it was early February. I just didn't know which day. We've been negotiating with when we can make it work. Their schedule, our schedule, when we're in hearings, when you're not shutting down the government.
Now I know the key.
Now we know it's the 11th.
Now I know the key how to get stuff out of you. I just got to whip out a calendar, and all of a sudden,
whip out a calendar, put a yellow tie on it.
Will the gentleman yield? Perhaps we could get the gentleman's commitment not to shut down the government in February.
Did those talking points go out to all of you this morning? Like, did everyone get the same talking point this morning?
No, it's just a fact.
We're back to the government shutdown? I mean, the American people and the media have moved past that. You guys are
it was your
you guys are
government
flooding
shutdown
the zone
that
every day with
prevented
more garbage.
the appearance of the Attorney General before this committee.
Look, I can do it
So
too. Why did you
it would
take
be
the
nice to
American-
get your
why did you take
commitment not to
healthcare
do
away
that
from the
again.
American people? I can do it too. Why did you take healthcare away from the American people? You invaded Venezuela, so we stopped talking about affordability. I mean, I can do this too, guys, all day.
Mr. Moskowitz, would you yield?
No, I'll end it in.
No, I want you to yield to me.
I'll end my moment since the chairman gave me the 11th. So.
Well, you can yield to the. It's your
Oh,
time.
sure.
You can
Since
yield if
said
you
I'll
want.
yield, I will
Okay.
yield to Ms. Crockett.
Okay, thank you so much. There's a lot of conversation about shutdown, and I'm curious to know if you can answer just a couple of questions for me. Who currently controls the Senate? Who currently controls the Senate? Answer the question.
The Republican.
Thank you. Who currently controls the House?
The Republican.
So if there
Is this the same test that the president gets when he does the?
I think it is. Okay. I think it is. The ones that he claims that he actually passes. But nevertheless, so if the government shuts down again, would it be on the Democrats or the Republicans?
The people in charge, the Republicans.
Oh, okay. Okay. I just thought that my math wasn't mathing. And then the last thing that I have for you, actually, Mr. Chairman, is there any reason that we can't get the Attorney General to come in before your January 31 deadline? Because it almost sounds like y'all are projecting that y'all are about to shut the government down, and then you will go ahead and use the excuse that we were shut down and so she couldn't get in.
We're scheduled for the 11th. She'll be here the 11th.
Oh, okay. I'll yield.
Gentlelady yields back. The gentleman from New Jersey is recognized for an amendment.
Let's go to Ms. McBath first.
We have one more speaker on the bill. Okay, I think the gentlelady from Georgia, and then we'll come back to the gentlelady from Texas.
Thank you, Mr. Chair. And I'm going to actually talk about the bill. Okay, so this bill would actually defund the police, eliminate essential public safety resources from local communities, and actually punish crime victims for policy decisions over which they have no control. It is cynical, misguided, and it's wrong. Republican fear-mongering about bail is just one thing, but it's another to play partisan games with law enforcement, crime victims, and our safety. This administration has already eliminated and canceled hundreds of millions of dollars that support vital public safety functions and essential services for crime victims. But this bill goes further, weaponizing our nation's cornerstone crime-fighting program, the Edward Byrne Memorial Justice Assistance Grant Program, also known as Byrne JAG. Law enforcement agencies across the country rely on Byrne JAG funds to fight crime. The funding reaches every state and supports every congressional district, red, blue, urban, suburban, and rural. And how And now that and that is actually how it should be. Public safety is not partisan, as it has become here in this committee. In Georgia, burn JAG grants provide direct financial support to innocent victims of violent crime, including victims of sexual assault, domestic violence, and child abuse. These grants help combat elder abuse and human trafficking. They support sexual assault response teams and put the latest forensic tools in the hands of law enforcement and first responders. They fund data analysis that helps Georgia make smart, evidence-driven policy decisions around public safety, criminal justice, and victim services issues. And they support training that raises standards statewide. That is just the tip of the iceberg. I could go on and on about the many uses of burn JAG funding in Georgia, which is, my district, or any other state or district in this country. Public safety matters to all Americans, and there has never been a partisan litmus test for burn JAG support. That's how it's supposed to work, and that's how it has worked for almost 40 years. It's a model for how the federal government can support state and local communities. But this bill would disqualify jurisdictions from receiving burn JAG funding if they don't fall in line with Trump's partisan agenda that is not based on fact and it's not based on truth. This bill would penalize states that have modeled their pretrial detention systems based on our federal courts, which boast an arrest rate of less than 2% for individuals arrested for a new offense while on federal pretrial supervision. It would even disqualify jurisdictions where the most violent offenders are not eligible for bail, like in federal court where dangerous offenders charged with violent crimes are preemptively detained. How does any of this make sense? The American people deserve to be safe in their communities. They don't need more partisan hype. We've heard enough of the partisan hype here today already. We should be working together to support states and localities to reduce crime and hold dangerous offenders accountable. I urge my colleagues to join me in opposing H.R. 5213. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Gentlelady from Texas recognized.
Thank you so much, Mr. Chair. So as many of you know, I not only represent Texas, but I have obviously represented well over 1,000 people in court as it relates to criminal defense cases. And so this is something that I know a little bit about, and I don't know if y'all truly understand what it is that you put into writing, which is why we shouldn't just do knee-jerk things, and we should be very thoughtful as we are crafting legislation. So some of you may or may not know that both Texas and Tennessee are pursuing constitutional amendments to allow judges to deny bail for more violent crimes, moving beyond current limits where bail can often only be denied for capital offenses, kind of like what that ICE officer committed, because usually when you execute somebody that way, you could be charged with a capital offense. And so in a state like Texas, it is already a situation where that kind of officer should be soon to be defendant would actually then go in before a judge, that judge would arraign him, and then that judge would make an assessment. And just because you're charged with capital murder doesn't necessarily mean that you are going to be denied bail, but that is such a serious offense and serious accusation that constitutionally it is one that has been historically justified as a means to hold someone without bail. And the reason that we don't hold people without bail is because we have this little nasty thing called the Constitution. And in that Constitution, it says that there is a presumption of innocence. And sometimes what happens is people are innocent. I mean, we know that y'all may not have y'all's current president. If he was incarcerated for his crimes and never got bail, he may have just been sitting there for a long time, but we know that he didn't even have to really go and spend any time in jail when he got arrested for crimes in 4 different jurisdictions, both state and federal. But nevertheless, so what we do is to make sure that a defendant is cloaked within that, we have a balancing act, because everything about the Constitution is about balance. And so if somebody has a long history where they have gone out, committed violent offenses over and over and over, then a judge has that information in front of them. And mind you, the best person to decide what you will do as it relates to bail is a judge, because the judge is able to judge every single situation and determine whether or not someone is going to be a threat to the community, because that's what it's actually supposed to be about. Bail is not supposed to be punishment. Punishment is supposed to come after the fact. Bail is supposed to be to assure that someone actually shows back up. So if they have a history of fleeing, that is something that a judge takes into consideration. If they have a long criminal history, that's something they take into consideration. If they are facing a significant amount of time, which is why when someone is accused of a capital offense, such as this ICE officer who should be facing significant crimes, then they look at the fact that maybe like in a state like Texas, if you are facing a capital offense, you are facing death or life without possibility of parole. And so when you are balancing this, you have the ability to judge the credibility of the witnesses that are gonna come before you and testify about why that person may or may not be a threat to the community. You have the ability to make these assessments. For us to take away tools does not make sense, because we don't know every individual situation. You are taking power away from the judiciary. And so I think that that's also problematic. But let me continue on. The reason that I say that I don't think that y'all thought this out very well is because what is the meaning of substantially limits cash bail? Because when Texas and Tennessee decided to go in, they decided to limit how many people could actually get cash bail. They have decided that they want to deny even more people cash bail. So you may end up cutting off funds to Texas as well as Tennessee, because they literally are in the process of changing the Constitution to actually limit how many people qualify. So you may want to go back and read your language, or it's okay if Texas doesn't get the money because, you know, we got a surplus. So anyway, I will yield my time.
Gentlelady yields back. Unanimous consent request from the gentlelady from Georgia.